Yeah.
Okay. Now that the meeting is being recorded.
Okay.
So as a child, I just had this childhood love affair with Tony Dorsett. So, I just.
That line is long, Doc. That line.
Childhood love affair. So, but by the time I got to like college days and stuff, I really had an affinity for the Buccaneers because I love Doug Williams, and then all those Seminoles started going to school there, so I really got in line. Then I got married, and my husband was a diehard Raider, so I had to keep peace in the house and wear black and silver. Then he passed, and now the person who has my attention now is like a diehard. So I feel like I got all these split personalities going on.
That's all right.
What it is. That's what it is.
I'm gonna start taking applications when the Cowboys make the Super Bowl. Okay.
For the bandwagon. Okay.
Listen, wait. All I got to say is now, Lamar Jackson not looking too bad. You see, he had that comeback. He's
he's from Pompano. I know. Throw it out now.
I know.
He's from Pompano.
Broward County. Actually, he's from Boynton. He's Palm Beach, but he was born in Pompano. But he went to school. He learned his football in Palm Beach, according to the Ravens website.
Doc, Judge, you better ask him. He's coming back to Pompano. He don't visit Boynton. Anytime he comes back in the hood, he's in Pompano. We all out there over there by the McNeil Park hanging out. He's over there. Him and Kodak Black. So they all hanging out in Pompano. Pompano new spot. We got people driving in Pompano we ain't never seen before. We started with one.
So Pompano is a spot.
Yeah. Real quick, I had to call the sheriff. Almost had to call the current sheriff because I sit on the housing authority for Pompano, and Kodak been talking about all this, Golden Acre stuff, and the next thing you know, we got a whole bunch of people standing on the roofs over there. I'm like, what's going on? Yeah, doing music videos on the roof, and so we got to figure this thing out.
I bet you they didn't have permits for that.
No, there wasn't any permits. The neighborhood gave the permit.
He's been throwing around his money, so
right.
Money talks.
Right, he done donated some AC units over there.
Oh, so you're the one that snitched that got him thrown off the property. Okay.
I ain't snitched, but we do have liability.
Now we know.
You end up on the news one way or another.
All right. We're gonna get started. I want to thank everyone for joining us. I sent you an email, Dr. Wanza and Chief Evans. Welcome, everyone. Let us begin with our self-introductions. Anyone? Members of our board? Say your name, who you are, and the organization you're representing.
Colonel David Hawks, Executive Director for Department of Law Enforcement with the Broward County Sheriff's Office.
Thank you, Colonel.
Alona Holmes on behalf of the NAACP.
Board of Weeks Public Defender's Office.
Michael Bell, Community-Based Connections.
John James, also with the Public Defender's Office.
Good afternoon. I'm Valerie Wanza, Broward County Public Schools.
Travis LeGrand, Statewide CAP Coordinator, DJJ.
Mr. Walters, I think you're trying to say something. Okay. Who's next?
Okay, I could go. I'm Judge Carlos Robola. I'm with Circuit Court Judge in the Juvenile Delinquency Division.
Director of National Economic Council, Brian Deese. I want to thank you for the leadership.
Guys?
See, my speaker's not working.
I hear you now. I hear you now. I think Roosevelt having trouble with his speaker.
No, I am. I thought you heard me, Madam President. For everybody that don't know me, I work at the whims of the president. When she said jump, I jump. If she don't say come down, I find something to hold on to.
Okay. All right. Thank you.
I'll go. Cassandra Evans, Chief Probation Officer, DJJ.
Johnny Sanders, Officer of Prevention Services, DJJ.
Dr. Rosalind Osgood, Broward County School Board.
Are you on the road, Doc? I see. Okay.
Yeah.
As usual. Ms. Phillips?
Yes, so sorry, I'm on.
Who's I'm?
Is Ella Phillips.
Okay, thank you. All right. Mr. Watkins, raise your hand. I see you're saying I'm here, but there are 85 Watkins, and 2 of them have declined already, so. All right, Commissioner Holness, are you there, or is it staff? Mr. Watkins, self-introductions.
Sorry about that. Here, David Watkins, Equity and Diversity, Broward County Schools.
Thank you. Okay. Commissioner Holness, are you there, or is that staff? I see something in the chat here.
I believe it's staff.
Okay. It's probably mean he's on the road. All righty. All right. So let us be reminded of our norms. Our cell phones placed on a vibrate. Raised hands when you want to be recognized, and we'll do the electronic hands. Maximum of 3 minutes per person. Respect all others' opinions and address the board members respectfully, please. All righty. So we were missing some folk last month, but we started and we had asked the Public Defender's Office and also Judge Holmes to work on juvenile expungement. We learned that there have been some statute changes, and there is certainly a need to ensure that our children who have successfully completed diversion and or civil citation, and they do have records, we want to make sure that they are aware of expunctions, the process, and the different types. And so with that, Mr. Weeks and Judge Holmes, if you will enlighten us, please.
Madam Chair, if Judge Holmes would allow, I would defer to Mr. James, who has prepared our packet that we suggested we were going to prepare. You know, one of the things that came up through this conversation is that we need to have the children that complete diversion successfully have the information to act quickly to seek that diversion. John's put that pack together, and I'm going to allow him to present that behalf of the office.
Thank you, Mr. James.
Good afternoon again, everyone. So what we did was we were able to put together a juvenile expungement packet, primarily that would be dedicated towards those juveniles that have completed diversion. Unfortunately, is really only for those diversion completions for misdemeanors. The statute doesn't permit it for those that commit felony offenses that are oftentimes given diversion. In this county, what we see is that any non-violent felony offense is usually subject to potential to complete diversion, but unfortunately the statute only allows for misdemeanors. So with our packet, we go through it and we explain that how to complete the packet. I was able to speak with a representative from the state attorney's office that provided me a contact person for their office for when the juveniles have to complete. There's a form in the packet that must be completed by the Broward State Attorney's Office. So that form is there. I provide them an example or show them that form, with the packet. Also provide them the contact information for the person from the State Attorney's Office. And it's also a letter for them to use to make contact with that individual when mailing the form for completion or emailing the form. So they can simply pretty much rewrite the letter in an email format and send it over to the State Attorney's Office so that way the form can be completed. There's also a contact information. Sergeant, is it Sergeant Holmes or Captain Holmes? Excuse me, I'm sorry.
Colonel,
forgive me, Colonel Holmes. And I emailed you, and I still don't even know your title. So forgive me, Colonel Holmes. Colonel Holmes also provided me the contact information for someone for fingerprint purposes. So we provided that information as well with inside of the packet. Then we also have a letter for them to send over the packet to the Florida Department of Law Enforcement. It's a letter that allows them to introduce themselves, identify the fact that they have all the requested and required forms, and then for them to mail that packet over to the Florida Department of Law Enforcement. It's instructions advising them that it's completely advisable, so to say, for them to, one, send it certified mail, and then also two, to ensure that they keep a copy of the packet for themselves, so they'll have an opportunity to review it. So that is our juvenile expungement packet for diversions. We didn't get a chance to, the other different forms of expungement are available. We didn't prepare packets for those because those are a little bit more extensive, that require a few more things that need to be done. So we wanted to wait on that one. But however, the juvenile diversion one we did complete. So we have one and we'll be submitted it to the body so you guys can see.
let me ask you, Mr. Weeks, I know that you went over this last week, but will you go over again the different types of juvenile expungements that are available to our students or children?
There are actually, and I neglected the last time, there is the packet that John prepared for if a child successfully completes the version, they are eligible to have their records expunged. There's also a form of expunction for children that are the victims of human trafficking. I neglected to point that out last time. That is a special, very special form of expunction only for the victim of human trafficking. You're saying, why would you need to have something expunged if you were the victim? Well, oftentimes victims of human trafficking are forced to engage in criminal activities by their trafficker. And if law enforcement certifies and the state attorney certifies that they were the victim of the human trafficking that then caused them to engage in the criminality, that is a special type of expungement. That is different from FDLE. That is a judicial form of expungement. And it's a very unique process that you're going to need the assistance of counsel to walk you through because it's very meticulous. And then there is the standard form of expungement for those children that have engaged in a non-forcible felony, and they may be eligible for expunction as well. That's through the FDLE. We have a template draft of a packet on that particular form, but we wanted to make sure we worked on the exit letter for those diversion expunctions first, get that completed, and then we'll work on the packet and make both of all of this information available on our website. We're doing a website refresh, and a lot of this information we want to make sure it's really easy accessible. We'll have the packets, we'll have an explanation of what this means, how to access it, and where it needs to go, and have all that available, and a contact person in our office to reach out to help walk you through it in the future. So once all that's completed, the paperwork, the packets, then we'll put it all on the website and then get feedback from the community on any adjustments that we need to make. So there are actually 3 forms of diversion expungement. Judge Holmes, you can correct me if I miss one,
I'll jump in. I'm gonna
Go
let
ahead.
you finish. There's more.
Okay, you go ahead.
I don't want to interrupt. Finish up.
Go ahead. You go ahead, Judge.
I think and thank you all for allowing me to be absent last week. I did watch the entire meeting last night, and so I made a few notes to go over. But I think Mr. Weeks really did a wonderful overview of what's out there. I think for the purposes of what this board is doing right away is the civil citation program. And so therefore that diversion expunction really has to be put into place and done right away. Because as you mentioned, Mr. Weeks, that people are buying information. But I will tell you this, juvenile records enjoy privacy. And they don't get released unless and until the child is either bound over as an adult, direct filed, or is an adult already, and the state can pull in the juvenile records and put it on the score sheet. So while it's fresh and you get the information that the child has finished diversion, the state and the public defender's office, I wish the private bar could get in on this also, because they tend to, they get that withhold or they get that diversion and then all process, and then it's more money for the child to deal with them. So I don't know how, maybe you all can talk to BACDL, that's the Broward County Defense Lawyers Association, or even establish, as they've done in Dade County, a pro bono section of the Black lawyers, where they're on the phone every Wednesday, and people can talk to them about their legal problems, and if they need an attorney, then they're given names and stuff. But the lawyers don't have to tell their names. It's just, I want to talk to a lawyer, and that way they know that they need a lawyer. So that's important for our purposes immediately, is to get on that diversion. And I believe there is a representative from the state attorney's office on now, because I think the last time you were asked, what forms are you using? I think in the past, because it's the state attorney's program by statute, they have the forms. So Ms. Gloria will give you all the forms to use. You don't have to reinvent the wheel. There is a form, however, on the FDLE website with drop down. They are preferring the electronic. And to get back to the packet that you have, when you're dealing with FDLE, the first thing and only thing they want at the beginning is for you to get that certificate of eligibility, right? They don't want a packet, they're not gonna read it. Their website even says, the first step in getting the expunction is to apply for the certificate of eligibility. They have lawyers on staff. Even though somebody may be applying for expunction, they have the right to say, you're not eligible for expunction, it's going to be a seal. And you were correct. What's the difference? Seal is closed off to the public, but not to certain entities like the Florida Bar, the Florida Medical Association, Department of Business and Regulations. Even firearms can get the juvenile record to see in this state. So it's not closed off to everyone, but it is sealed. And the most important thing, the child, as they go forward, if they're asked, have you been convicted or arrested? And that's an improper question on an application, but their job, their questions. So if you've been arrested, they can truthfully answer no, and not be subjected to the penalties of perjury. So it's important to do that right after they, do that diversion program. Once the state notifies your office, And maybe something can be worked out with the private defense bar when, you know, they get notification or the child is notified. I don't know how they notify the child. So maybe Miss Gloria can tell us about that, but that's important. So that's the first one. And so that is the juvenile diversion expungement. That's under Florida statute 943-0582. There is another remedy under the statute, and we kind of overlooked it. There is a self-defense expungement. And the reason why there is a new self-defense expungement is because of the stand your ground statute. And stand your ground does apply in juvenile cases. There was a case, I think Judge Williams was the judge, TP versus state. I haven't cited cases in 3 years for Florida, so I could be wrong, but it sticks out in my mind, TP versus state, where the fourth DCA remanded the case for Judge Williams to determine whether or not stand your ground applied on a battery on a bus, a school bus. So that's important to have because your office may want to take those cases before a judge, and the statute under stand your ground says there will be no criminal prosecution or civil lawsuits. So the FDLE on their website, they do now acknowledge a legal self-defense expungement, and that's really important to know. That's going to be under, let's see, I can't read my own writing, 943-0578 Florida statute. So those are the two. You mentioned the human trafficking. The state attorney's office is going to be real important in that because they're prosecuting the pimp, for lack of a better term. Is there a new word that they're using for them? They were pimps in my day. I don't know whatever they are, the handlers or whatever they call themselves. But as you said, a lot of those children commit acts of prostitution. Some of them even, do robbery by sudden snatching, which is a felony. So those crimes that those children, young women, young men were forced to do because of their pimp, that human trafficking statute kicks in. But it's the state has to certify that they were the victim. And the good thing about that statute is that it's not limited to just one case. It's all the cases they did under that pimp can be expunged so that they can start their lives all over again. So that is really something for us to look into. So the self-defense, the human trafficking, and the diversion program, those are the three that I think are really, really important for the purposes of this board and can be implemented immediately. But the first step is, don't give the kid the whole packet. The first thing they need to do is that go online or either drop down or mail a letter to FDLE asking for a certificate of eligibility. And what they have to include with that is $75 and fingerprints and a disposition. Okay, so that should be easy to get because every kid gets a dispo in court. I don't know, do they go back to court? I know adults come back to court for the null pros.
Judge, if I may, as to that point and then a few other points. So we have two different issues that happens with that. There are some times where the children are not charged at all for the crime. They're given a letter and it's automatically diverted on the case.
Do they have to come to court to
no,
get?
They do not.
Say they completed. Okay, good.
Right. So when they don't come to court, they'll just get a certified letter from the program or coordinator or organizer.
Is it CC to you?
No.
To your office?
No, because unfortunately, Judge, if we don't get those cases or those kids when they're arrested, because a lot of times that kid may receive an NTA because there's an NTA program that we're doing now in the 17th Circuit where if a child is arrested for a misdemeanor, they're not allowing them to do civil citation, but then they may give them an NTA at the time of arrest, telling them when to come to court. Well, before they get the date for court, they may receive a letter in the mail from a program. It may be the BSO program. I know NAACP, if I'm not mistaken, has one. Urban League has one.
We used to, we don't anymore. Mhm.
Okay. And then they're advised to participate within the diversion program. Some kids often elect to do that instead of coming to court. And then what happens is that the case manager for the judge would then advise the judge that kid is now already admitted into a diversion program, now allowing that kid to work through that diversion program. So the judge never resets that case on their docket, because if the kid actually
they never get a court case number. That's the way it is. I was just trying to find out how so we have to really rely on the state.
So and to that, that's why I raised my hand. I like to give credit where credit is due, especially since I've worked with them regarding this process. We're putting together the juvenile packet that we did. I've been informed, I've been advised that they actually put together a packet for the children at the time that they finished diversion. So upon their completion of diversion, they're helping them at that point to complete the diversion, the actual expungement packet. And the interesting thing is with the statute doesn't require a child in its diversion completion to pay the $75 processing fee. So the $75 processing fee is waived, and then that kind of helps them. So at that juncture, now they have the letter already from the state attorney. They have the letter from the program coordinator as well. Now they just need to do their fingerprinting and complete their one-page application form signed in front of a notary, and then they're fine. That application can be submitted directly to the Florida Department of Law Enforcement.
Okay. Yeah, I'm thinking adults. Like I said, I apologize for my ignorance. I never did. I covered for Bobby Collins for a week in juvenile, and you know, there's too many cooks in the kitchen when you're trying to help a child over there. So I don't know how Judge Robolo does it, but if the state is willing to continue that, but we need the state to initiate and to.
I think that didn't happen, so that's why Gordon's office, we already covered that, and that was not. I know they're doing the adults, but the kid thing wasn't popping, so that's why we asked the public defender's office.
I would say, Madam Chair, the reason why they advised me that it didn't happen was because of COVID. So they were trying to slowly reintroduce themselves back to having a juvenile workshop for expungement. I
heard that too. No, I heard that. Yeah, it wouldn't even happen before COVID. But yes, I understand.
Okay.
But no.
I'm the messenger when it comes to this part. I'm not.
You don't write these jokes. You just tell them.
I'm gonna give it to you how I received it. So if we gonna receive it together or we ain't. So that's.
We've received that before. Yes, I get it. You don't write these jokes. You just tell them.
But and then there's one more thing. There was a conversation, and I'm beyond my 3 minutes, Madam President, but I wanted to try to cover everything that came up.
Yeah.
The LNP statute, the cities, I think it's Lighthouse Point, Coral Springs, and Plantation. They have what they call their internal exemptions. They like to not issue civil citations for loitering and prowling. I heard the explanation given by Colonel Holmes and I think the representative from the Fort Lauderdale Police Department. The reason why I would ask that they rethink that, or the state can rethink it, I have yet to find one police officer that does an LNP arrest correctly. I provided you with a case, Madam Chair, yesterday, as early as 2020. They're still not arresting people correctly on loitering and prowling. 856 is the problem. I will volunteer to go to the academy and teach them how to do it, but most officers just, if somebody's just walking up and down the street, they write up an LNP, and a lot of county court judges just let it go. You know, credit for time served. You know, no contest credit, time served. But they don't look at it, and most of those LNP arrests are not done correctly. And so, you know, you get a kid that's going to get arrested for something that's going to get tossed out of court later, and they still get the cuffs and they take the ride. So that's something that I would love to address with them. I really don't want to tell their officers how to do it correctly, But I've thrown out a lot of cases based on improper arrests for loitering and prowling. And that's why most municipalities, I know they love it because it's better than a field card. You get more information to make the arrest, but most of those arrests are not correct.
We're
So
going
I
to
don't
get
know what to say.
shortly from Ms. Gaynor regarding their meetings there. And in the meantime, we have Dr. Osgood, Mr. Walters, and the judge. Dr. Osgood?
Thank you, Madam President. My question was kind of answered because I was thinking process and wanting to know how we connect with those programs. I know in the crazy days of my life, when you was being discharged from jail or from a program, there was always a discharge planner or worker or a caseworker or somebody that was signing off that you had completed something. And I was wondering how we engage those individuals to help those children. And then I was wondering if someone qualified for a public defender, if that waived that $75. So some of that was answered with the gentleman that spoke, but we have to close the door. Giving the kid the packet, I think is good, but we know that they need a little more help. So I don't know if it's possible for maybe the group that's working on this to actually meet with the various programs across the county to make sure that this is a part of their exit plan, the plan that they finalize. Even if they're saying all the kid has to do is mail it or email it, that's perhaps something that worker that's working with them can do for them. If it's an email, it's not costing anybody any money. It's just a little time to do it. Then I know that legal aid also has a lot of free services available. So I was just thinking more of the ending and making sure that it's actually completed and doing what we can through those programs to help those children and those families complete the process.
Thank you. Mr. Walters?
Thank you, Madam Chair. Just for the judge, you only give 3 minutes, and it would probably take me 3 hours to rebut some of the stuff that the judge said. Not that what she said was incorrect, but I have my opinions on the application of things, and but I won't do that. But I would like for Mr. James or the public defender to tell me what happened when a person who had a felony go to the diversion program but his record can't be expunged. What happens to the record, and what statute, state statute covers that?
Madam Chair, if you would allow, if you complete diversion and your case is dismissed and you have a felony and you're not eligible for the misdemeanor diversion opportunity, you are still eligible for the juvenile expunction opportunity. It is the dismissal, the no pros, the withhold on a non-violent felony that will make you eligible for the expunction. However, it's one time. That's the one time burn that you get. The diversion expunction is a freebie. The self-defense expunction is another freebie. The human trafficking expunction are a third freebie. You can have all three of those. But once you use that one-time life expunction for any felony or any misdemeanor outside of those three exceptions, you only get to use it once. And that's the issue. So oftentimes you have to really talk to the family and the child about what this means for them, that they need to, order their life and order their steps and know that there's no more getting in trouble, because they've now got a clean slate and they need to stay on a clean slate moving forward. So yes, you do have an opportunity to expunge your record if you have a felony and it's a diversion and it's not a forcible felony, but it's only a one time and you don't get to do it twice.
Thank you, sir.
Judge Rebola?
I'm unmuted. Okay, good. Two things. Number one, Judge Holmes, you are amazing. It is in fact the TP case that basically said that stand your ground applies to juveniles also. And it was in fact Judge Williams's case. That you're amazing, but I've known that for many, many years, having appeared in front of you and having had the pleasure
Trying to
of
convince Mr. Walters of that.
on a Madam President, Judge Holmes is also very, very correct in this problem with loitering and prowling. And I don't want to, law enforcement can speak for themselves on this, but I can tell you that, and Mr. Weeks, our public defender, and Mr. James, the chief of the juvenile division, will tell you that the one charge most consistently found not to have probable cause is in fact loitering and prowling. I'm sure not only in the juvenile division, but also in the adult division. I suspect because law enforcement likes to use that as a catch-all. Well, I don't have a burglary here yet, and I don't have a trespass, and I don't have, so I'll just arrest them for loitering and prowling. When, as Judge Holmes rightly pointed out, there's certain elements to a loitering and prowling, and one of the key elements is that it has to be observed by law enforcement, not by the neighbor, not by the person who called it in. Law enforcement themselves have to observe the loitering and prowling conduct for there to be a valid arrest. And it's amazing to me how many times that just keeps coming through, and I don't hesitate not to find probable cause in that. Thank you, Madam President.
Thank you. Ms. Brown.
Madam Chair, we addressed this, I think, a little far back, and I was on the phone and I didn't have a chance to, chime in. But I wanted to mention that my office, Delinquency Case Management under Court Administration, we work very closely with the State Attorney's Office. So every youth who is referred to diversion, we internally start to track and monitor those cases from the onset. And any youth who has a court date and a petition hasn't been filed because they've been released with a notice to appear, we will ensure that their cases are canceled, because we also work very closely with the diversion providers. So we have a very good system in place to ensure that the youth who enroll in diversion, they don't have to appear in court. And if they do appear in court because, a petition is filed, then we have a 6-month hearing. We will as well give them the information for the expunction and what they need to do that. And we work very closely with the diversion provider as well as the State Attorney's Office. So I'm happy that Judge Holmes and the Public Defender's Office, they're going to be taking that on, because I certainly think it is a need there now that they're not having those workshops right now.
Thank you. Yeah, the providers, once the case was sent to them, this is how they used to do it with the State Attorney's Office. The provider would receive the case, they would contact the family, and if the family agreed to come in and participate, then they could certainly send over a form provided by the State Attorney's Office to cancel the court date. The only problem came in if the program was not able to reach the family because of whatever reason. But normally, I think, if I recall, I haven't been in a while, but it used to work really well. But that was, under the other administration there. Thank you, Ms. Brown. Colonel Holmes.
Good afternoon, Madam Chair and other board members. I want to just briefly touch on a couple of things. First, the loitering and prowling. Judge Williams, you're absolutely right. That's been a problem for quite some time. Deputies tend to utilize that as a way to initiate a stop and try to investigate further, but they do it improperly. And I definitely feel as though we have to do much better in training our officers and our deputies to if they're going to use that statute, they have to use it properly, because it's affecting so many cases and so many innocent people are being jammed up. And like you said, Judge, they go for the ride. And if you're not breaking the law, why should you go for the ride? So that we have a ways to go with that, but that's been used for many, many years. And we have to definitely improve in that area. The second thing I wanted to just touch on is human trafficking. Human trafficking is becoming prevalent, and it's a crime that we in law enforcement have been dealing with recently, seeing a spike across the country. Actually, right now, as we speak, well, in the next 20 minutes, I have our ICAC unit detective, our internet crimes against children detective, that's speaking to a group of youth at a middle school here in Broward County, because our youth are becoming victimized big time by these traffickers. And what we're doing here at the Broward County Sheriff's Office, we're making it mandatory that all of our employees, not just deputies, all of our employees are going through training courses to learn how to identify. I mean, you could be at a mall shopping and you could see a young kid and know that something's not right. But I think we in society tend to blow it off, and we could be saving a young person's life. So that's why the only reason why I know the sheriff has taken initiative to train all employees, and that's huge. Hopefully our society can take that approach, and we can start saving some of these young kids' lives. And one of the things that we have to be aware of too, with any major events that happening and like even in sports, you have the Super Bowl. We always see in law enforcement an uptick in human trafficking. And whether it's the Super Bowl, the World Series, et cetera, we have to step up our game in law enforcement to curtail this. And one of the things that I know some of the executives in law enforcement have talked about is going to the state legislator and the lawmakers and making the penalties a lot more strict. So we're going to be looking for support from people in the community to address these things. But those are two areas I just wanted to touch base on to let you know that we in law enforcement are definitely aware, and we're trying to do our part to work on and addressing those things.
Thank you. And Mr. Weeks or Judge Holmes, is that who initiates in the human trafficking expungement? Who initiates the expungement process?
The state attorney's office. They've got all the information. They should take the lead.
Okay, so
this is one of the areas that I've had some great concerns about over the years. When it is the state attorney's office that initiates it, it's also sometimes, let's put it this way. I've seen instances where victims of human trafficking have been the key witness in cases against their trafficker. They have been essential in investigations with their trafficker. They have been instrumental in identifying trafficking networks, and they have still been prosecuted. And it has caused me great frustration when you ask a victim to have the courage enough to first speak up, and then you don't protect them when they were used to commit a felony. And we need to look at that, and more importantly, look at the number of children and adults that have benefited from that human trafficking expungement, not only in Broward County and Florida. And you will probably be very, very surprised to learn how few children and adults have benefited from that, because every time you see, and you have to think about this, every time you see a prosecution for human trafficking in the paper, and you see them quite often, there should be a victim associated with that. And some of those victims, many of them, have been involved in, through their trafficker, forced to engage in all kinds of criminality. But do they get the benefit of the protections? And that's been my great frustration. Ask for the numbers. Ask for how many times they've actually certified that this child is eligible for having their cases expunged due to human trafficking. Cassandra is well aware of the data. And should, it's not very oftentimes triggered, is my point.
And one more thing, isn't there another type of expungement where if a child is arrested in error, say they got the wrong kid, that there is such a thing? What is that called, and who initiates that process?
You're 100% correct. That was a glitch bill some many years ago, where you could not get your case expunged even though the state had certified that you were the wrong person that was arrested. And there were some amendment to the expunction process. So you are eligible to have your case expunged and sealed if the state certifies that you were the wrong person. I will research that and include that. I'm taking notes because you guys were.
It's called an administrative expungement.
Hold on. Go ahead, finish, Gordon. Go ahead.
Judge Holmes is right. It's called an administrative expungement. It's a special type of expungement outside of the sealing, outside of the diversion expungement, the human trafficking expungement, the self-defense expungement, and the one-time expungement. There's that glitch special administrative expungement. And you know what? I'm glad that I'm on here with such learned attorneys that remind me of all of the nuances, because I'm taking notes for the updates that we're going to make so we can memorialize all this stuff for the future. Because you were right, that is another version of expungement.
And to either you or the judge, who initiates that process to begin?
The
administrative. You want me to answer that?
Go ahead, Judge.
Who knows the answer?
Well, I got the statute here. So it's either the state or the arresting agency. The state attorney's office, and maybe one of their representatives can speak to it, or Gordon, you may know better. They used to have a unit in their office called the Not Me unit, where someone gets arrested, either their brother used their name or somebody stole their identity, and they went to that part of the state attorney's office, and they filled out all the paperwork and everything, and then they brought the paperwork to the judge, and I signed a whole bunch of them. So Judge Robolo, are they still doing that?
They are, and the unit was named after someone who ran the and they weren't a lawyer, but they were the administrator of that unit. I'll find out what the name of the person that runs that unit is, because they still do have that. And you're absolutely right. If it's not a person, you're basically completely innocent. There should be no reason why you should be punished in any way whatsoever.
So either the arresting law enforcement agency or the state attorney can initiate the process. Colonel Holmes, did you know that there was such a thing?
Yes, it brought back memories when Judge Holmes mentioned that. I could tell you just from experience as a young deputy, not me cases. A lot of times you have investigators that come across an individual and they don't want to go those extra lengths to find out the true identity of that person. So they just go and arrest them just to move things along. And then you have other investigators that will go that length. They will stand there and wait 20, 30, 40 minutes to determine and investigate the true identity of a subject. One of the things that has happened in the past is that you've taken innocent people down to jail. They find out that the person isn't the person that the officer alleged they were. And down at the jail, they go through the process. And then even at the fingerprinting part, they learn that it's the wrong person. Well, what ramification is there for the officer that took the shortcut? And how about the records of the people that, we didn't find until later that it wasn't that person? So I tell you, from law enforcement perspective, things have gotten better, but there's still investigators out there, law enforcement officers out there that take shortcuts, and they don't want to go that extra length to find the true identity of a person. But that's something internal that we have to correct. And there has to be some type of actions taken by the agency themselves. And sometimes the state too. If it's intentional, yeah, because everyone's human, they people can make mistakes, but when it's done intentionally, then they should be prosecuted to the full extent of the law, just like anyone else.
So your agency, if they did make a mistake, would have no problem initiating the process if you were the arresting agency?
Oh, no problem at all. And we have internal levels of and checks and balances. But do things slip through the cracks sometimes? Yes. But there's a difference between making a mistake and doing something intentional as well. And when you're doing something intentional, then you should be dealt with accordingly.
Okay. And Judge, I saw your hand up. Judge Holmes, real quick. Did you have something?
No, I apologize. I saw a hand up on the screen. I thought it was mine and I was playing with it, but I found that it's not my hand. So it's now gone. So I apologize.
Okay. Mr. Walters, did you have another question, or is your hand still up from before?
Madam Chair, I'm just amazed that every time I come to these meetings, I learn so much more. That you know, I'm beginning to believe that I'm one of those who knows not that he knows not, and but Judge Holmes and the public defender and Mr. James and everybody else, including you, Madam Chair, I am still learning. I guess that's why I'm still trying to live.
All right. Well, we appreciate that. We strongly suggest that you continue. Okay. Thank you. And Chief Evans, you were going to update us on what expunged civil citations look like in JJIS. You're muted. You are muted.
On mute.
Okay. Well, okay, you were off for a second.
Okay.
All right.
All right, perfect. Thank you. My apologies. So what I've discovered is that the expungements of records in our juvenile justice information system is completed on the delinquency side of the system. And so with my understanding of that, therefore because civil citations sit under the prevention side, then those records are not expunged because the rules for expungement are not what's been described today. So, so the short of the answer is civil citations are inside of the prevention web, and that's where they sit.
Forever?
Until we move records into our archive status. So we follow the rules of public record retention as a department. So various ages, certain types of incidences are moved into an archive component of our system. But there's no expungement of civil citation, as there's nothing that prompts it to happen. So like I think maybe 5 versions or maybe 6 versions that were described today, those prompt us. We receive an order, the department goes in and extracts those records and all pieces of the record out of our system. On the civil citation side, there's no prompt for that on the prevention side. So that's how I understand the system to work. But that data is not shared beyond the department, is my understanding. Nothing that is more than aggregated data, no de-identified data.
Okay, I'm a little confused. Now, the last time I listened to the video, so I could be clear, you said that there's certain number of entities that have access to JJIS.
Correct.
So that will continue to be. So these entities, to include law enforcement, they will, unless and until the statute changes, will have access to these records of these civil citations where they, were accused of an infraction, technically were not arrested, but they've done all that they had to do, but the records still exist indefinitely?
On the prevention side, it will still continue to be there, yes.
Wow. Okay, and there's nothing in there that what separates civil citations on the prevention side from the programs that DJJ pays for. So what separates civil citations from the Capaligas or Lamplighters that receive monies from DJJ, assuming that they did? What would separate?
Within the system, there's various, in a non-technical term, they're called buckets of data sets. In the technical term, they're custody units. So a youth can only be assigned to a particular custody unit and only entered into that custody unit based on a provider's permission. So when you get to the prevention side, to imagine kind of opening the door within the prevention side, then we have various programs in the system, and those kids are then registered in that program. So the databases, there are demarcations within the database based on the type of program and then the purpose of the program. And so it's some various ways behind the system they define that.
So Officer Holmes, in his first year, is going to have access and look into JJIS, and he's going to be able to determine the different programs that little Gordon has participated in, and because you're going to base that on whether they arrest a kid. So he's going to be able to look at that and determine whether it was a program that they voluntarily participated in versus a civil citation program versus whatever other programs you all that may fund.
You'll see when they go into the initial search screen, it's identified there that the child is in prevention. You'll see one for civil citation, and then you see one for delinquency. So you will see of the options available in our continuum, where they land on the continuum. So they can see that from the very beginning. The ability to interpret what they see, to listen to the discussion about loitering and prowling, I'm sure there could be some additional training that helps folks better differentiate what the data means, but it's pretty clear at the very beginning. It says prevention on the top. I mean, like, it's
right. But if Lamplighters is under prevention, you have Colonel Holmes, who just started yesterday.
Right.
How is he? We really expect him to be able to distinguish the difference between all these different things, because his job is to, based on the sheriff of Pinellas County, his job is to look and to determine whether he's going to arrest this kid based on what he sees in the system. So we really expect him to know all these and be able to determine whether this is a good kid who just participated in a program because it was available or because it was civil citation.
That's one of those questions that no matter what the answer is, I don't think it may be the right answer. But from the department standpoint, I would like to believe that law enforcement will be training their staff who are going to make these decisions as to what this means, right? So the department makes no assumptions that they know how to read it, because while we provide them the information, I can't say with any degree of certainty that Colonel Holmes on day 2 knows the differentiation between delinquency, prevention, or civil citation. I think that would be beyond what I could even speculate if they knew the difference between those. So,
yeah, and I think if I may add, I think that's the type of situation where, depending on how well trained that officer is, and what their intentions are, okay, because you're going to have some officers that's going to say, hey, you know what, I want to get this kid off the street no matter what. I could care less of whether he has a civil citation in there or he's a good kid or not. And those are the bad officers, of course. But then you're going to have some that's going to look in that file to see, all right, well, you know what? Here's a kid that may have made a stupid error, stupid mistake. And, he's not a bad kid at all. Maybe we should, give him a ride home and talk to his parents, or take an easier route than to give him a ride. But it all depends on, and that's what I think Ms. Evans was alluding to. It all depends on the officer themselves, and how they're trained and what their attitude is that day. You never know. I can tell you that with some of these, some of the officers and their demeanors and their attitudes. So.
Right. So Madam Chair, I'm currently looking at the system. And so I'm looking at a test record, and there are 3 specific columns that from this initial glance, one says prevention, yes or no. One says civil citation. It could be a yes or no, with in parentheses indicates the number of civil citation options that have been used, and one that says delinquent. So making a strong assumption that an officer at that juncture going out on the road would know the difference between those service deliveries. That's what it would say, even without looking at the youth's face sheet to determine the name of the program. It just categorically lists them that way. So that's what it looks like.
Yeah, and if I may add too, you have some agencies and some parts of the state that are more advanced than other agencies in their trainings, and that may
Broward County as well. I don't know, over in Mayberry, I don't know what they got going on in Lighthouse Point, but we're gonna talk about them in a minute. Okay. So, all right. So, the Dr. Wanza has to go to her ribbon cutting. Mandatory mask in our schools, real quick, Doc.
I was actually typing it in the chat, but okay, I'll just give the verbal report. So I don't know if Dr. Osgood is still on, but the board.
I'm here.
Okay. Do you want to speak, Doc? What the board voted
About the mask?
Yes, ma'am. I just didn't want to speak if you wanted to.
Yeah, I will. The board did not change anything. Okay. We are moving forward to continue to mandate masks and suffer whatever consequences the lunatic in Tallahassee wants to give us. The new rule also came with a different way to quarantine, which kind of suggests that if someone is exposed to COVID and they don't have any symptoms, that they don't have to say anything. The board is being very consistent. We are concerned about students and our staff, and we believe strongly that all of our data shows that our mask mandate policy is what's helping drive the COVID positivity rates down in Broward County. We have had only, in the most days, the largest number of kids was 10 that refused to wear masks. So we don't have an outpour of people that want their kids in school without masks. We believe that we would have been very successful in the court challenge that we initially put forth. And that's why we got a new rule from a crazy surgeon general who was dusted off from Harvard and put into a position to be told to write some crazy policy. So right now we are also taking legal action against this new rule from the Surgeon General. We're taking legal action against this new penalty that we had on Thursday when we went into the court of kangaroos that basically said that all of the school boards in Florida that are mandating masks are violating the law, and that now they're not only going to withhold 1/12 of our salary, but for Broward and Alachua, who applied for a grant from the federal government to replace the salary money, they're now going to withhold 1/12 of that salary money as well. So school districts now being drawn into a political fight that's personal with the governor and the president on the back of our kids and our families and our staffs whose lives are being put in danger. So we're going to continue to fight. We believe that ultimately we will win in court because we are within the guidelines of the Florida statute that gives us local authority over school districts. We actually believe that the governor himself is violating
the Parents' Bill of Rights. We've also done some additional work with the NAACP attorneys and Attorney Bruce Rohar from Nova, and I might not be saying this last name right, but basically, when the Constitution talks about liberty, and the lawyers can better explain it, it's not literal. Your personal liberty cannot be exercised to the extent that it causes harm to others. So we don't know, we're almost, halfway through this week. Normally at some point on Friday, right before 5, we get something else. So we are anticipating this. But let me just be clear, this whole thing is causing major disruption in education in schools. Our staff from Dr. Wanza's level, the district level to principals are now just engaged in responding to all the punitive administrative stuff. They have to do contract tracing, all these other added things that further prevent us from education. It's also causing major unemployment in school districts. People are resigning and quitting. People are not coming to work in school districts because they want to be safe and protected. And they just don't know if the governor is going to start going after them even personally about the mask mandate or the punitive things that's happened to school districts. And finally, it's creating a whole nother level of stress and anxiety. So we're seeing more guns on campuses, more fights, more bomb threats. It's just creating a climate of violence and disruption for school districts. And we have to continue to be aggressive and speak up and out about it, sending letters, giving voice to it. We can't just sit back and wait for the court part to play out. We have to continue to keep the pressure on. And Dr. Wanza, please add anything else you want to add.
You were very eloquent.
There has been an increase of children who do not, other than the few that we had before that are refusing to wear a mask?
No, on the most day, the largest number we've ever had since this started was 10 students. There is no increase. Parents have shown consistently that they want their kids back in school face-to-face, and they're okay with wearing the mask. Student government leaders have talked to students, the interim superintendent, the principals of engaged students, and students want masks. They say that they're not cool and they can be uncomfortable, but they don't want COVID. I had a student this week die at Dillard from COVID because when they are home on the weekends, they go into places where people are not wearing masks. Now, if a student is outside, they don't have to wear their mask outside because we know the air is circulating a lot differently than if they're in a closed-in environment. But this is something that's unimaginable. You just can't think that any person with basic common sense, a doctor told me this morning, you don't have to be a doctor to have common sense to know that people need to wear their masks when they're in small environments that are closed in around other people. So our data shows that what we're doing is the right thing. It shows that it gives us the evidence to support our stand. But we're in a time where we don't believe in science and we're not making data-driven decisions. We're just being punitive to school boards. It might ultimately mean that the governor comes back and removes school board members because ultimately what they want to do is have the state control school boards. There are a lot of other pieces of legislations about making school board races partisan. There are all kinds of things going on for the state to take control. When you listen at the Commissioner of Education, they constantly tell you that it's their responsibility to run school districts, to run schools, to state education. And that's not what the Florida Constitution says. That's why you have elected school board members. So we have to pay attention to the policy the additional policies that are gonna come forth in this legislative session. And we have to be willing to challenge them legally, and we have to keep speaking out and educating people about the real thing that's going on. And that's to take over the state school systems so that Black kids don't have a chance to be smart and exercise their gifts and talents. They ultimately end up down there for attorney weeks to defend them.
Thank you. I see a question from, I think I did see one from Ms. Phillips. Sure, in there.
I did, Madam Chair, and it was actually before we talked about masks. Just real quickly, just something to keep in mind, and I'm not sure. It always comes up about law enforcement and training when we were having a discussion about law enforcement and their participation. I think it's very key to find out who does that training, and that it's consistent when whoever may or may not, but the information that they get in the understanding of what, you know, we would hope that they would do for those who can. And it's just very key that law enforcement is on the same page with the information, whoever is going to be doing that training.
Colonel, do you all have someone to teach your deputies how to read JJIS on the prevention side?
Internally, we have, I mean, we're the largest agency in the county. We have access to all types of training, but and we have people in our administration that promote training immensely, and our sheriff is really into training. However, we're talking about the entire Broward County and getting the other municipalities on board with the same mindset of improving training and making sure everything is up to date and all of their employees are up to par is totally different. It's something that we can, I mean, it's been brought up at the Broward County Chiefs of Police Association's meetings quite often, the importance of training, but you have to have buy-in from all the chiefs. And I think that's where it lies. Here internally, I'm really not overly concerned because, like I said, our sheriff is very progressive when it comes to training and making sure our deputies up to par with all the legalities that they're supposed to be on top of. But it takes more than just BSO. It takes the entire county.
Okay. Mr. Weeks.
Thank you, Madam President. I just want to just commend Dr. Osgood in her leadership over there at the school board. It is just incredibly warming and welcoming, and to see you navigate this incredible storm that's going on over there with the governor and all the antics that are being played around this mask issue. You guys are doing incredible work. It's under very difficult circumstances. You have an incredible team around you with Dr. Wanzer and Mr. Watkins and all of those great leaders that you have down there in the school board. And I just wanted to acknowledge that because you're right. Every Friday you get some new twist. You get some new counterattack. You get some new way to try to undermine the health and well-being of the children in this community. And you are the final firewall. You are the firewall to ensure that our kids are educated in the schools and, more importantly, protected and healthy. So I wanted to say that publicly because, you know, it is tough what you're doing, but we really do appreciate it, and we need your kind of leadership. But I also want to backtrack over to Cassandra and just ask a simple question. And I already know the answer, but I want everybody else to get a feel for this answer as well. Is there any way for a child to petition to have their civil citation purged from your system after they have completed the civil citation program and their case is now resolved and concluded, to have them out of your system as a dependency side child or a prevention side child?
Should I raise my right hand, Gordon? For this, I almost feel like this is sworn testimony, and this is really my left hand, so it won't be legit. But to my knowledge, I am unaware of any particular course at this juncture for that. But I will raise that issue to our statewide civil citation coordinator to ask about if it is requested by the participant who successfully completed this portion of programming. Is that a possibility? And if so, legally, then how would we avail this opportunity to all children? And would it be one of those processes that goes back retroactively? Because the name of the game is a clean slate as you enter into life without with as few barriers as possible. So I will certainly take that back to our statewide coordinator. Thank you for the question there, because you were reading my mind. But I also, Madam Chair, had a question for or response back to to Miss Phillips as well.
Go right ahead.
So I too was thinking along those same line, Ms. Phillips, as it relates to training, because a system or anything is only as good as what people know what to do with it, right? So, you know, a car can be extremely dangerous if you don't know how to operate it effectively. And so while we do have standard training modules currently available on our internet site for how to use JGIS and things of that nature, I am thinking about taking to offer the training. So again, consistency, it needs to come from the department because we are best positioned to explain our system. And so because we have the platform of Zoom where you get thousands of participants, you know, I think it would be a worthwhile venture to host a couple workshops, just to see how they will go, and to open the floor also for some additional questions, because we don't know if our material is sufficient until we've asked folks to give feedback on it. And so I'm willing to take that to our data integrity team and to ask them if they will be willing to conduct at least maybe one workshop before the year ends, just to see how it will go and what it would yield. So I did hear your concern.
Thank you.
Let me ask you a question, Chief Evans. So
yes, ma'am.
My kid participates in a basketball program or summer program at YMCA, and DJJ funds that program, which I'm told requires them to put my kid's data in your prevention web. If I'm a parent, I find out, and I don't want my kid's information in your prevention web, because my kid is I don't want to have any type of dealings with DJJ, the database. Is there something that a parent could do to have their kids' information removed from the prevention web if they participated in a funded program and that program entered my kids' information in there?
The way the contracts read, if my recollection is accurate, Madam Chair, that part of program participation is the consenting to the data collection process of it. So I would have to run that past our, Mr. Sanders is on the line, our prevention team, to look at those contracts to see what allowances are in there legally. So I'll double check on that. I remember this question probably a couple years ago. We were actually meeting in person downtown. I think it stopped at the contract piece, but I'll ask the question again since I'm going to be talking to them.
And one more thing, do you require your programs, your paid programs, to tell the parent that if your child participates in this program, their information is going to be entered in DJJ's juvenile information system? So explain to them what that means. So I guess my question, are these parents consenting? Do you know for a fact that these parents are consenting to having their children's information entered into JJIS?
I will ask. That's in a different umbrella of the organization. I'll ask what the intake package looks like for a prevention program. And then I'll ask about the contractual requirement for data entry.
Dr. Osgood.
Thank you, Madam President. They are legislating this data entry because they need those numbers so they can forecast how they're gonna arrange their prison contracts. It's so clear. Everybody's being forced. All these laws are coming down about putting things into that database so that the state can use that database in a punitive way. I just want to throw that nugget. And secondly, I'm going to request that if you could find room at some point for us to have an agenda item. Representative Patricia Williams, the school board, met with the delegation last week, and she brought up this whole thing about how we're double dipping with SROs, where it's money that the state is wasting paying for safety, that we should put it all under the sheriff office. And when we tried to explain to her that the school board pays a portion and the municipality pays a portion, she couldn't grasp it. The sheriff would have to have all of that money, and then the sheriff doesn't have jurisdiction over the whole county with municipalities, but it's something that we need to just inform you guys in the details of how it works, how SROs are funded, and so that if this legislation begins to come down the pipeline before I get to Tallahassee, we have a strategy that we're not putting our kids in harm's way. Nothing against the sheriff's office. It just doesn't work like that when it comes to jurisdiction when you have 31 municipalities. But because she said it, and because she traditionally, you know, votes on the other side with these Republicans, and if you're Republican, I'm sorry, but y'all ain't being nice to my kids right now, so I can't give y'all a pass. It's gonna really, really hurt us. And it's something that we need to start strategizing and planning with now so that it doesn't become another drive-by on us.
Thank you, Doc. The question of the sheriff taking over, I haven't met a sheriff that is just thrilled to do that. The price tag, I think maybe either 19 or 20, Colonel, was just crazy money. It was, I don't know how many millions and millions of dollars annually that it would take in order for the sheriff to do. I mean, there's a whole the intricate piece that would be added to the budget that nobody, the school district couldn't pay for, and nobody else was going to pay for. The money was just outrageous in order to do it the way it was supposed to be done, assuming that all the other legalities could be worked out.
Right, and it would be a tedious process. And you're talking about, you know, we don't have the personnel to staff every school in Broward County. And there's municipalities that have their own SROs. So if all the money was to go to the sheriff, you know, then you know, these municipalities would lose a lot say so over how their municipalities are run, you know, and the schools within their municipality are run. It would create chaos more so than anything. But I agree with Dr. Osgood. I think an explanation needs to maybe some type of workshop where people can understand how the process goes right now and how the funding is split to cover all the schools here in Broward County and how we do that from a law enforcement perspective.
Yeah, we need to invite those state legislators, Madam President. They don't care what works implementation wise. They just do what they want to do up there and force it on us. So if we could give them the courtesy of inviting them so that they know when they go with this kind of crazy lunatic public policy that we're going to respond, it would just be very helpful. I'm kind of thinking right now that it's just around ignorance, but there was a lot of pushback in the discussion when we were trying to explain. And unfortunately, I haven't been able to get the sheriff to respond. 3 of my meetings have been canceled, although the sheriff has met with our superintendent. And I feel some kind of way about it because I'm the elected school board member and people just tend to overlook elected school board members. So if I'm not going to be the chair at the end of November, so I'm not going to be as nice going forward.
Thank you, Doc. That takes us to, and let's spend just a few minutes on this. Is there now a process in place at the clerk of the court's office for her to determine if those cases were civil citation eligible, and are we using? Has anybody checked to see if that is if any of those cases have been caught?
Afternoon, can you all hear me?
Yes.
It is not the clerk's office responsibility to determine civil citation eligibility. So the process is simply that they forward all misdemeanor offenses to our division, and then we would determine it from there.
So has she forwarded any back rather than putting them into the system?
We haven't had any issues with any cases being put back into the system that I'm aware of, but But nothing has come up that has generated a possible civil citation up to this point. A missed opportunity or civil citation opportunity, I should say.
Okay. And what law enforcement agencies have signed on to the civil citation plan from the state attorney's office, other than BSO?
In terms of signing on, I'm not aware of a signing on. I don't know that the final draft has been presented to the police chiefs for the civil citation. I would have to get with Mr. Pryor on that, because I know that was going through the attorneys for the police chiefs.
Okay.
But between that and the 12 and under MOU, there's been like back and forth between our agencies. So I'll have to get with you. I'll get you an answer on that. But in the spirit of continuing to do the informative meetings with all the police agencies in Broward County, Tamika Gaynor and I are continuing those meetings and doing them one by one with each police agency to make them understand the policy that we have all created and worked upon and what our expectations are in terms of issuing civil citation in every possible eligible case.
Okay. Tamika Gaynor, can you were gonna give us an update regarding the internal exclusions from a couple of agencies regarding issuing civil citation. I think Coral Springs on the battery, they agreed to review and reevaluate their possibly change, but first review, see what they're going to do. And then I believe Plantation and Lighthouse Point had internal exclusions for loitering and prowling. Has there been any update on that?
So we haven't had an update from Coral Springs. There was no plan for an update regarding Plantation and Lighthouse Point on what they were going to do for their policy. But since our last meeting, we had the opportunity to meet with Sunrise, and they had no internal exclusions, and we have 3 other agencies pending.
Okay, so plan is just they're doing it. That's it.
No, I'll jump in here, Ms. Gaynor. I think the way what she's saying is that we gave them the information. I gave my perspective on why we want loitering and prowlings to be included for civil citation. And I think they were just going to basically take that under advisement. And I think we definitely gave them food for thought. They understood that if it got presented anyway, that I would be returning that for civil citation eligibility, regardless of whether they wanted to make the arrest as their exception. So I believe they were taking it under advisement in those agencies, particularly Lighthouse Point. I don't have an independent recollection of Plantation, but I'm sure that we could circle back. Ms. Gaynor and I could always circle back to those agencies that we kind of left it out there for them to take back to their, superiors about what our thoughts were or the state's perspective on those types of charges.
Okay, but Plantation didn't actually say that they were going to review.
I don't think they were in a position to say one way or the other at the time, Madam Chair, because they were just getting all of, basically we were giving them a lot of information about what's taking place with civil citation and the expectations of all the stakeholders, and particularly the expectation of the state attorney's office now that we're going to be issuing them ourselves in those missed opportunities situations. So it may warrant a circle back to them, even if it's just an email to follow up. We can certainly do that.
Okay. Ms. Gaynor, missed opportunities?
Okay, Madam Chair, I'll provide you the information that I have, but I just like to say for the questions, I only have the information that's provided to us by the department because this report is generated by DJJ.
Okay.
Okay, so from the information provided, it looks like there were 3 missed opportunities. There are a number of others. I think there's probably 12 on the report, but a number of those are not eligible for the civil citation program in Broward County because they are domestic violence related. So there are 3 true missed opportunities. one for loitering and prowling, one for disorderly conduct, and then there's a third for assault and battery. And the reason given is because the youth refused to admit guilt.
Can you go back and go with the charges, review the missed opportunities and include the agencies with the charges as well, please?
Absolutely. The first one that I'm looking at is Coral Springs. That one is loitering and prowling. The second one is Hollywood Police Department, and that one is for disorderly conduct. And then the third one is Plantation Police Department, and that's for assault and battery.
And so and tell me again, I'm sorry, what's the reason for Springs on the loitering and prowling? Because I think they did not have they were not on your list they had battery, but they didn't have loitering and prowling.
So the reason for that particular case was it says that the reason was either not available or not provided by law enforcement. And then for the disorderly conduct with Hollywood PD, it basically says not identified as civil citation eligible. And that's the reason those are the reasons on the report provided.
What does that mean? Not identified as civil citation eligible.
So
Any
I
idea?
can't give, no, I would have to defer to Cassandra for that because this report and the data entered is completed by the Department of Juvenile Justice.
Okay, thank you.
If I may, Madam Chair, with regard to the loitering and prowling, youth with the loitering and prowling charge, they may not be eligible because they already have a felony case with diversion program. So they have a
Do we know that for a fact?
I just looked in our system. So they would not be eligible if they have the prior felony.
Ms. Evans?
Madam Chair, those reasons are selected by the agency. So I'm going to say that definition-wise, it's probably because they have some type of criteria that made them ineligible. But the agencies tell us the reason they chose not to do a civil citation. We just give them the options to select from. I would have to look, or Gloria could look to see for that disorderly conduct, what was perhaps written in the narrative of the arrest report that perhaps made them disqualified, but it's really a checkbox that they select for us.
And the Springs where it says loitering and prowling not valid?
That's because they didn't select anything. So they gave us no reason for us to enter into the system why they chose not to give us a citation. It's a void. It's a zero.
So what does the civil citation state attorney, what does anybody do when you have an explanation or lack of explanation and something like that? What does the kid do? If they could possibly could or could not have been eligible for civil citation, do we just say they didn't give it and that's it, or what do we do?
Well, in this instance, as by way of example, they were not eligible, and I think what Chief Evans is saying is that law enforcement just didn't inform. Pardon me?
Not available means not. She said they didn't check a box. So does that mean?
Yeah, it means they did not. That law enforcement neglected or chose not to give the reason why they did not issue the civil citation. But I'm giving you the reason why. The reason why is because he was not eligible.
And he was not eligible in the loitering and prowling at Coral Springs because he too had a previous felony?
Yes, ma'am.
So both the Hollywood kid and the Coral Springs kid had previous felonies.
Which one is the Hollywood kid that you're referring to? Because that says it involved
disorderly conduct.
I have not looked that one up yet. I can look that up now and see if I have anything on it.
Okay.
Is that
and telling us about the other ones that were not missed opportunities. You said were they all domestic violence?
Yes, Madam Chair. The other 9. Mm-hmm.
Which departments?
Oh, Tamika, do you have the departments right in front of you? I have to see if I have
The
it.
departments for the ones that were not eligible.
They're all, she said the 9 that were domestic violence.
Okay.
Let me see.
Broward Sheriff's Office, Coral Springs. There's another Coral Springs. There's Hollywood Police Department, Lauderhill, Pembroke Pines, and Two Sunrise.
Colonel, can you double check that one for BSO to make sure it was indeed domestic violence? It wasn't, you know, how you guys are identifying that?
Yep. Find out.
And so are we looking now still at these domestic violence charges and to figure out what we're doing here? Because I mean, you know, we've had over the years incidences where if they gave a particular charge, then it was automatically assumed that it was correct. They just kind of switched it from one to the other. So was it a fight between two siblings? Was it what we just need to know what's going on with those things.
With regard to the disorderly conduct, I showed that it came in as an aggravated assault with the second charge of disorderly conduct.
Okay.
So it involved an aggravated assault. And just so the board knows, when we get these reports from DJJ, I individually look up these cases as I just did for you now. I apologize, I didn't have an opportunity before today's meeting, but I do keep it on my desk. And I look up these cases to make sure that there is not, I follow up to make sure that there's not a missed opportunity. Typically, I end up sending it in an email to Chief Evans that also includes John James and let them know what those cases were and why they appear to not be eligible. I have yet to find a missed opportunity on these reports in the last few months that I've been doing this, but trust me, I'm, following up to be sure.
And the 9 domestic violence cases, what happens to those? Are they eligible for diversion or not?
It will be eligible for diversion if it is a first offense. And then also, I think I've said this in prior meetings, even if it's maybe sometimes a second offense that involves a domestic in those offenses, we still will divert, always constantly trying to implement services for the family in every possible scenario. But yes, they would be eligible for diversion as long as it's a misdemeanor domestic violence offense. Well, sometimes even in felony, if we can't get the family to cooperate otherwise, or they're hesitant to, we try to get services in place every time.
And tell us again, are these eligible for expungement?
Misdemeanor batteries would be, or assault.
Okay, but domestic violence in this case is not? Unless you're using your one shot?
Not if they go through diversion. If they go through diversion, they would have the diversion eligibility.
Okay. Thank you. All right. COVID. DJJ, Chief Evans. What can you tell us about the juvenile detention center?
Right now there are currently 28 youth in the facility. That was today at about 2:30, and the major has confirmed that the facility is not under quarantine.
Are the teachers and are they still doing virtual?
They should be in because they're not under quarantine, but I'll ask the major that question specifically.
Mr. Watkins, are your teachers out there?
Yes, our teachers are working in person at the facility.
Okay. Thank you. Okay. Colonel Holmes.
Yes, Madam Chair. We currently at the Paul Ryan facility, we have 9 juveniles. We had 10, but one had a birthday and became an adult and was transferred over to the main jail. We currently have 9 males, 0 females. No major issues at this time. We have 0 COVID cases there. Wearing masks is strictly enforced. They are attending in-class school with the teachers. One of the things that we've noticed from a law enforcement perspective, especially since school has just started, an uptick in threats at these schools and a uptick in the number of fights among the juveniles in schools. So that's something that we're monitoring. Our SROs are monitoring closely. Our threat management unit, they're following social media, because that's been a great tool for us in stopping widespread violence and prevention of something catastrophic happening. But we have noticed an uptick in the number of threats, and it's sad when you read about a kid that has made a threat, and we end up going to the home to arrest them, and they say I was just joking, or I wasn't going to do anything. But these are things that we can't take lightly, and we're working with the families, and hopefully these juveniles can get help and understand the seriousness of these threats.
Okay. I think did the school, the interim superintendent, make a video or something for the kids, Dr. Osgood, to talk about the seriousness of these threats? It seems as though I saw something there.
Madam President, would you restate that?
It seems like I saw a video or something that the district did. It may have been a video with the interim superintendent to try to discourage these kids from making the threats, even in jest or otherwise, trying to alert them about the seriousness of the matter. Is that correct? Seems like I saw.
Correct. So it's not just the threat. So, and I know you guys are older. I'm a millennial, born in the wrong generation. So I'm on TikTok. So there's been these series of TikTok challenges, crazy things like slap your teacher, shoot your teacher. And the kids are doing these challenges in fun, but they don't understand that they are against the law, and they put them in a legal predicament to be thrown out of school, to be expelled. So we've been trying to take an approach first to educate the kids, to educate the parents, not only about the TikTok challenges. We have an increased number in bomb threats. Kids are on Instagram and Snapchat threatening to blow up schools, threatening to shoot up schools. And sometimes they're just playing, but once they put it out there on social media, because of 7026, we are required to take certain punitive action against them. So the interim superintendent did a video speaking to the seriousness of it. There was another video specifically about the TikTok challenges. We've been working with the Principals Association, and we're looking to have our lobbyists do something on the federal level to see what kind of legislation we can put in place to have TikTok monitor that stuff. If they can kick Trump off social media for lies, then they should be able to shut down and not have such videos and those things posted.
Thank you. Gloria, your hand is up.
I think Dr. Osgood may have answered my question, but I was going to ask, because obviously the huge uptick in written threats, false reports, those types of things are clearly what our unit's dealing with on a daily basis with law enforcement agencies. And I know that they, Judge Williams as well as Judge Tudor did a sort of a public service announcement to parents that were put out through email, because I received that as a parent in the school system. But I was curious we were just discussing this the other day in our division. What are they doing to address it with the student population? But I think, Dr. Osgood, you answered that, because it sounds like you are directly addressing it with student populations, I'm assuming from middle school on up.
Yeah, we're trying to address it on every level. And I know that I've personally been in conversation with our superintendent about engaging students to address it. Mr. Watkins is on the line. It would be, something that's very good for our Mentoring Tomorrow's Leaders peer mentoring group and our 500 role model kids, for kids to do those videos. It's always good when we have judges weighing in and the superintendent, but we all know that young people like myself respond to other young people like me, better so than we do with adults. I also just want to take a moment to say that we had a recent situation at Walker where a kid came to school with an unloaded gun in his book bag. And I was very appreciative to the state attorney who took a strong stand and, set something in course where that kid wasn't arrested. It was clear that the kid's intent was not to harm anybody, but the state attorney could have handled it very differently, and that kid could have ended up being arrested and expelled from school. So I appreciate Mr. Pryor's, stand and his intervention with that we were able to work with that kid and his mother who carelessly left, the gun where he could get access with it and bring it to school, to kind of show it off, not with an intent to harm someone.
Excellent. You're very true. Very true. Mr. Watkins.
Thank you, Madam Chair. So Dr. Osgood is sharing, what she's speaking of. Also, she was speaking about the School Pride and Peace social media challenge. And so, through the chair, the district was charged with coming up with a positive social media challenge, which is part of their Think Before You Post initiative. And so there is, an attempt right now to engage schools and kids into a challenge to have judges. So she was speaking about the judges, the entertainment factor of how they can change this narrative from the TikTok to doing positive messaging. And there are also resources on our school district website around addressing social media posts. And the initiative is called Think Before You Post.
Okay. Thank you. Let's see what I saw here. Ms. Evans, you had a post, DJJ and BSO assessment team.
Yes, ma'am. Probably about, because I'm copied on all of the notifications for those type of charges. And so I reached out to, along with Sarah, had a discussion with Sarah Gillespie Cummings at the JAG, who reached out to David. We have a conversation plan to complement the discussion and the work that Dr. Osgood and the board is doing. Those videos were last shown when we were in school. So I think that out of sight, out of mind, our children may not even be aware of the consequences, but it's alarming. And so I just wanted to put it out there, because Michelle Green, supervisor over at the assessment center, made mention of the video link that we have. So I just want to just announce that we have this conversation. We're planning this conversation to take place because it is alarming, because all these cases are then internally staffed. And it's not funny, but these felonies are real. So I just wanted to post for everyone to know.
And Ms. Evans, you indicated earlier that Victor London was an attendee. I attempted to bring Victor London over. He declined. What I do have to do is get with his chief to give us this board must have a decision maker, and they must be empowered. And I'll give you an example. When we spoke to the sheriff, and I asked him to give us someone and empower that person to make a decision for the agency, and he said, you'll have Colonel Holmes, and whatever decision he says, I'll roll with it. If I differ with him, you'll never know about it, because that's how we're doing. So I need to get that type of person or senior leadership from the city of Fort Lauderdale to the chief, so that we could do that. And I see that you're still there, Victor. You should have come over when I asked you to come over in the first place. I can say that Fort Lauderdale, the chief did meet, and he said that London had asked him about the free fingerprinting, at least for the city of Fort Lauderdale? And he said, absolutely. And so at least I'm not sure, and Victor, if you can tell us, Mr. London, can you tell us if the city of Fort Lauderdale will pay for fingerprinting for those children who are from Fort Lauderdale, for fingerprinting for the purpose of expunction? Is that just for the city of Fort Lauderdale, or for kids that you all with neighboring kids? You muted, sir.
We made the agreement to do it for whoever comes to our agency.
Okay, thank you. And so we.
And I apologize. I didn't see your promotion request earlier. I've been here for the duration.
Okay. No problem. Anything else you want to share about Fort Lauderdale? I think the last time we saw each other, you had just gotten one of the agreements.
Yes, the juvenile civil citation MOU was signed and executed. So that's in effect, and we just got the 12 and under signed and executed.
Okay. And I want to say that Fort Lauderdale basically looked at the state attorney's civil citation program and did a copy and paste. They didn't make all these internal exclusions going on. They want to do the right thing about the children. And so that was when they finally got it, it was a no-brainer. And I saw it, so I knew it wasn't just talk. We saw it happen. So we're very thankful for that. And I think we're going to see some good things with the new leadership now that it's steady and not, interim and that sort of thing. So good talk we also had with the city of Fort Lauderdale police chief. Thank you, Major London and Fort Lauderdale.
And Madam President, I am your Fort Lauderdale high-ranking official that will be representing on this board.
Okay, well, you're gonna have to make some decisions now. If you got to go back and ask the chief everything, that's really not helpful. So if he empowering you to say yes, we're gonna pay for the fingerprints, that's what we need you to do. So if that's a different process, then we have to talk offline. But we need you to be able to speak for your agency, just as the colonel does. Now, if the colonel get in trouble later, we won't even know. But his decision gonna stand. But so that works for us. We need a similar setup with Fort Lauderdale.
You have it.
We appreciate that. Gloria, did you have something else, or is your hand up from before?
Oh, I'm sorry. It's up from before.
Are there any other comments? Anything for the good of the order?
Madam Chair.
Madam Chair, I just want to go on the record and also give some praise to the state attorney for taking that stance with that child with the gun in the schools. I also endorse what Dr. Gosgood said. Sometimes we just have to acknowledge the right decision. So he did the right thing at the right time. So I give him praise for that. I hope he continues to stand strong as these issues continue to emerge. If they look at it and they recognize that there was no ill intent, it was a mistake and things of that sort. Those are the types of cases that should not enter in the criminal justice system or juvenile justice system. That's the type of deference and how Judge Williams said, give a little bit of grace to the children. So I give him that praise, and I want to give it to him publicly. So Ms. Michella, please send that back and let them know that we give praise when it's necessary, when it's deserving, and I will give it publicly, and I will also chastise publicly as well.
Well, you did that earlier in the meeting, so I appreciate the end.
Okay. Also, I want to say publicly that everything that we have asked of BSO, they have done. They have worked with us on every issue as we sit here today, and they didn't wait a long time or do all those things. They made sure that their GC knew that juvenile justice and the way we treat our kids was a priority. And so, Colonel, I'm certainly thankful for your assistance and for your continued support of our children in Broward County. We appreciate you.
We'll be here for you always.
Chief Evans.
Madam Chair, I just want to two quick announcements. In a separate conversation with the state attorney's office, I was made aware of that a sealing and expungement workshop for adults has been planned for 10/28/21. During that discussion, I'd also mentioned about the concern presented from our board as it relates to a juvenile, the need for a juvenile seal and expunge workshop. So the coordinator of this event was not over juveniles, but she was made aware of that. And then I just want to also announce that the department is hosting its Restoring Hope Faith Conference at the Florida Hotel in Orlando. So if you need a breakaway, there's a conference going on that's all about children and restoring hope in the faith process and the partnership of faith agencies and entities with the department on the 26th and 27th of this month at the Florida Hotel. And so I want to extend that invitation. And I just want to double back. I did go a little bit further to those domestic violence cases. And thus far, and I can give a more in-depth report next month, but I did go back to the beginning of this year. And there are about 69 youth who were on this list. And I think it's time for us to take a hard look at how we handle domestic violence. It is an opportunity to interrupt violence in a home and all the consequences or benefits of doing so. Because of the cases that I looked at, many of the children, either no action was taken or they were diverted, right? So that opportunity could have been availed at a civil citation level, not leaving that imprint, and also infusing services into the family. So I'll dig a little bit deeper into the data to provide a little bit more next month for the committee, for the board rather.
Thank you. And I just had one quick question. Who was the coordinator of the adult expunction workshop?
Who I spoke to, I don't think she's a coordinator, but made the announcement was Jamar Johnson. She spoke to our board before.
Now, Jamaro does, as she's spoken to the board before, does amazing work with the sex trafficking pieces. So I think that she could certainly be helpful with that expunction process for victims of human trafficking. So that would be probably just be a phone call and a quick conversation because
we've already communicated with our office plans to do one after the adult one. We're taking one at a time, especially because of COVID. So I've already communicated with the office about.
Gloria, I was speaking specifically to the human trafficking one, and that might not be one-on-one that you want to do a public type situation with. So
No, I'm sorry. I thought you were talking about expungement for juveniles in general. We're going to be doing that after the adult one, but I'm also in communication with Jamara on all of the human trafficking efforts as well.
Right. So we just need to figure out about the human traffic expungement pieces on how that works. And since she lives and breathes that stuff, I think that would be a no-brainer in order to do that.
Yeah.
Okay. Mr. Lagon.
Yes. Good afternoon, everyone. In reference to your question about the JJIS system, I did speak with the contract person that's over prevention contracts, which is our Mr. Brett Musgrove at the moment. And he did say that our use names that are entered in the JJIS, they're not a part of the civil part of the JJIS. So if any kids are arrested and it's charged, the kids who are in prevention programs are not in that category with the delinquency part of it. So there's two separate parts. So if they're in prevention, it does not show in delinquency for youth that are being placed in JJIS.
So the kids that go to the YMCA, isn't that a prevention program? That say the one I'm using YMCA as an example of say a funded program that you all might do. Are those not in the prevention program?
They're in the prevention program, but they do not show with the delinquency part of it. So it won't show if a law enforcement officer go in and look at it, they won't see that youth name that's in the prevention part of the JJIS.
So you're sure? That's not what your other folks said.
What I would do, I would have Mr. Musgrove to give you a call. When you brought up the question, I wrote notes and took it down, and I invited him to come in so we could try to address that, so I can give you an answer before we got off the call. But he's saying it shouldn't show with the delinquency part of it.
Let's do this. Let's bring that one back so we can be sure that that's not what's going on. But I will invite him to come on so he can give you more update information on that for you.
But I
Okay.
was just relaying a message that was given to me from him because he's in depth with the contract process of the providers in our state with that issue.
I'm just concerned because I haven't. There's a sheriff who's not ours that is really dependent on that information for his detective to determine whether so he can track children and so on and so forth. But anyway, anything else for the good of the order? Okay. With that, Mr. Walters, unless you're talking about adjournment, then we are done.
Madam Chair, I was going to let you know it was either time to do a motion to extend or a motion to adjourn, one or the other.
We are adjourning, sir.
Thank you.
All right. Thank you, everybody. We'll talk soon. Appreciate it.
Thank you.